Hi guys, it's Kathy. I hope you're doing well. We made it to Thursday. Sandra, they called. They called me. They wanted you to come into work, please. You don't get a day off. Alright. Monica's still in California. So we're going to limp by alone without Monica. But it's okay. We'll make it. We will. Micah's here. Okay. Thank you, everybody who came into Discord to talk yesterday. That was way cool. Very fun. Today, we are going to do landlord-tenant, just small claim stuff today. After I do this, boom. And I think it's all in Indiana. I don't think we go to Georgia today. So, you can't say no. There are people who are sick. There are sick people who need a nurse. You have to go. Or, you could just stay and watch small claims. Like, you know, a tenant pouring cement down a toilet. That's a normal thing to do, right?
Yep. If you want to come to the table up here and please remove your hat. Is there a Austin Bulock? Sir. Come up here, sir. 2601 EV31, Judy Christensen. Ma'am, please take your visor off. We have both parties here today in person. We were here for the notice of claim. And you had vacated the property, so we're set for damages. So before we begin, is there an ultimate dollar amount you're asking for today, Ms. Christensen?
Yes.
What is that?
$3,990.69.
And Mr. Bulock, are you contesting that dollar amount?
Yeah.
Yes?
Yes, sir.
Okay. So I'm going to place you both under oath. We'll take some evidence. Please raise your right hands. Do you swear affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
I do.
Yep. All right, Ms. Christensen. So now's your chance to tell me exactly what you're requesting and why.
Okay. I rented the house at 509 East Washington Street in New Richmond to Austin Bulock, November the 1st, 2025. As per the lease, he was required to put the utilities in his name. We were busy remodeling another house, and it wasn't until December 30th that I became aware that Austin had not changed the sewer water trash bill into his name. I sent him a text message with the utility office number. He didn't respond. In January, I sent Austin a text telling him his rent was late. He gave no response, but according to his testimony, did vacate on the 18th of January. I went into the house. There was nothing there except a new 55-gallon aquarium of fish. The next door neighbor, Matt Newhart, told me that Austin had offered him the aquarium, but he didn't want it. The thermostat was set at 78 degrees. The propane tank was at 4%. I called Sagamore Propane. They informed me that Austin had never moved the account into his name. I spent $1,914.69 for the fill-up and the propane Austin used while in residence. I sent Austin another text asking for the house keys and garage door remote. No response. I had to remove the front door lock and have it rekeyed at Haley's Lock and Key, 2210, and spent $74.90 at Steve's overhead door for new remotes. I spent $125 to file eviction. After the eviction hearing in March, Austin approached me in the parking lot. He told me that he had my front door key. I told him that he was too late, that I'd had to have the lock rekeyed. He then offered to give me my garage door remote. Again, I told him he was too late. I'd had to get new remotes after 3 days of trying to get Menards remotes to pair up without success. My new tenant, Brooke Morgan, told me that Austin showed up on her doorstep alleging that I never communicated with him. I showed her the unanswered text messages. He never answered phone calls either. He told her he was staying in a mobile home park in a trailer owned by his new employer. That same employer told me he'd never heard of Austin when I called looking for him. I had the eviction notice served there anyway since I'd seen Austin driving a company truck. It managed to find him since he showed up for the eviction hearing. I'm asking for a judgment for the January rent 3 tanks of propane plus the propane I had loaded prior, filing cost, and the water sewer trash bill for 3 months, which came to $476 since they charged me for late fees too. So it all comes up to $3990.69.
Oof. Brent, she actually might be in Australia right now. We don't know. Here's why I say that. She was complaining about gas prices. And yeah, I mean, gas prices here are pretty bad. They're really bad. But they're not Australia bad. I think in Australia you guys are up to $11 a gallon? Oof. I could be wrong. Oh, that's really bad.
And I have the receipts.
Okay, so we had the propane fill-up door.
It was at 70%. I took a picture when he moved in.
Hold on. So
Okay.
propane fill-up, I got the dollar amount for that.
Okay.
The door removal was a garage door the opener.
The rekeyed was $22.10. $74.90 at Steve's overhead door.
It was $22.10, so $22.10 to get the house.
To get the lock rekeyed and a new key made for it.
Okay, and then how much was the back rent that was owed?
Well, he moved in November the 1st, paid the first month's rent of the deposit. So I used the deposit for December. So that makes him liable for January, which would be $950.
Okay. Mr. Bulock, do you have any questions for Ms. Christensen?
No.
I'll give you a chance to testify here in a second, but do you have any questions for her?
No questions.
Okay. What do you want me to know?
Well, when I vacated the property, the propane tank was still at 60%. Never set my heat over 72 degrees. And with that being said, December rent was paid at the bank right over here on the corner. I don't have that receipt with me today, but I'm sure I could go over there, request one. Other than that, it all sounds pretty fair.
You're right. That is my fault. I should not have said that. I don't know how many gallons
Okay, I'm just making sure I have all the numbers.
or vice versa.
So $1914.69 for propane fill-up, $74.90 for the garage door, $125 filed for the eviction, $476 in utilities, $22.10 for the lock, $950 rent. Was there another expense?
Late.
So I'm only getting $35.62.69. Yeah, 26.
The water sewer trash?
That was the 476, correct?
Yeah, $476.
$400 and what you just testified to. So what I'm going to do today is find, given the evidence presented today, it's going to be a judgment of $35.62.69 in favor of the plaintiff. So we'll get that judgment entered, then you can work with Ms. Christensen or just pay that through the clerk's office. Okay, that's all for today, sir.
Thank you.
So then, Sarah Carissa Hale. Okay, ma'am. Same position on 2602 EV32. So I'm going to place you both under oath. We'll take some testimonies. Please both raise your right hand. Do you swear or affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
I didn't.
Yes, I do.
Okay. All right, Ms. Christian, just like before, tell me what's going on here.
Okay. I need to amend the judgment amount in the case of Carissa Hale. After she vacated the property at 214 South Harrison in Linden, I discovered that she had changed the lock sets and deadbolts. We had to drill out the locks in order to gain entry. My husband went to Home Depot, purchased new lock sets and deadbolts. We secured the house. The electricity was off and there was no heat or water. The town of Linden shut off the water for non-payment. Carissa had unscrewed all the light bulbs. The microwave oven plate was missing and there were bags of trash piled up outside and on the back porch. My husband oversees that account, so I wasn't aware that Carissa had not paid her rent since October. She didn't reimburse us for the electricity that she used from August through most of October, 30132. She was supposed to have that in her name when she moved in.
What was the 30132 for?
Electricity from August through October.
Okay.
I had to pay the water sewer trash bill of $324.18 to get the water back on because she never paid the water bill. Unfortunately, there's more now. I re-rented the house after sweeping, mopping, and removing the trash. The new tenants told me the toilet wasn't flushing right. At first, we thought it was because of the rain, but we finally went there and pulled the toilet. Someone had poured cement down the toilet. I have pictures. We had to take a hammer and chisel to remove the cement. Picture 1 and 2. Then I had to remove chunks of cement, toilet paper, and poop out from under the toilet and in the sewer pipe. I called Johnson Sewer Service, but they told me there was nothing they could do until we tore out the entire bathroom floor. It's a slab on grade. They charged me $150 for that information. I then called Anderson's Plumbing in Lafayette, hoping they would jet it out. They gave me an estimate of $3,300 to tear out the bathroom floor and run a camera down the sewer pipe. I did not use them. We paid $729 to American Mechanical to dig up the sewer pipe in the backyard and install a new line. They cannot fix the rest of the problem until the tenants are out or on vacation. I have a description and estimate for that work. Okay, so they would remove the existing bathtub and enclosure, remove existing toilet. That's a new toilet, by the way. Remove existing floor tile, cut and jackhammer out the concrete floors, approximately 8 feet by 2 feet, replace the drain pipes to the sink and toilet and bathtub, connecting to city sewer pipes when proves clear. Replace concrete bathtub, toilet, and floor tile. This price includes the material, labor, and taxes. That is to be executed once the current tenants either take a vacation or vacate. Right now, to use the bathroom, they have to have a wastebasket next to the bathtub or next to the toilet because they cannot put paper down the toilet. Okay? Now, so that's the estimate for that work is $55.21 for the remaining work. The money we are out is above $10K, so I would like a judgment against Carissa Hale in the amount of $9,999, and I would like her charged with criminal vandalism.
Hale, do you have any questions for Ms. Christensen?
No questions, Your Honor.
What do you want me to know?
There's absolutely no way that I've ever poured cement down a toilet in my life. I wouldn't even let my child flush his own toilet paper, let alone cement down a toilet. That is not accurate. That is not true whatsoever. I did change a singular lock on the back door, which was a deadbolt lock. I didn't change any other locks whatsoever. Just a singular deadbolt lock on the back door because the door did not stay shut on its own. So the only way that the door would remain closed is if you had the deadbolt latch because the back door did not work properly. Yes, there was trash outside because she wanted me out by the 15th and I was out by the 13th. So I couldn't set things out in time. But by the time that I had gone back to replace her broken deadbolt on the door on the 14th, the day before that I was due to be out, all of the locks in the house were changed. So I couldn't even get in to replace her already broken lock. So I did not change any locks aside from a singular deadbolt. Yes, I do owe her back rent. That is correct. But I did not, absolutely not do anything to the bathroom. I did not do a single thing to the bathroom whatsoever. When I lived there, everything was functioning properly. I had no issues except for with the back door.
Okay. Ms. Christensen, do you have any questions for Ms. Hale?
I have a statement. It is
Hold on.
useless.
So, what day did you move out? Ms.
I
Hale?
moved-
13th.
Wait, I wonder if the landlord jiggled the handle at all, because that fixes a lot of issues in a toilet. You just jiggle the handle. Maybe she just needs to do that.
I'm asking her, Ms. Christensen.
I vacated the property on the 13th, but I wasn't due to be out till the 15th, February.
And Ms. Hale, when did you get that released? New tenants in?
Of the 1st of March.
Yeah. Okay, so do you have a statement, Ms. Hale? Or Ms.
Yes.
Christensen?
It is useless to put Teresa under an oath because she will lie under oath. She lied under oath when she had me in court for harassment. Okay, she lied under oath then twice. She's lying about this. This picture is something I noticed. It's a picture of brand new cement on the sidewalk, and I'm like, what is that? That's what I noticed when I came in after Teresa was gone. This is a picture of the drain under the toilet, and you'll see there's just a little half moon for the water to escape, because the rest of this is concrete that we had to chisel out. We spent 3 months previous to her moving in remodeling that house. We put down new floors, we redid the cabinets, we put a new roof on it, new metal roof on it, and a crew of, let's say, 3 to 5 to 6 people were always in that house working and using the toilet. And it functioned perfectly before she moved in. Now it's full of concrete. This is what it looks like after we chiseled the concrete out. I pulled out, with rubber gloves, thank God, about 1/3 to 1/4 of concrete chunks, toilet paper, and poop out of the water line and the sewer underneath the toilet, trying to get that drain clear. Okay? This is the hole that we had to have dug in the backyard. That's a 5-gallon bucket for scale. Okay, and we had to lay a new piece of sewer, but now we have to go underneath the house because there's still concrete there. The tenants that are there now have to use a wastebasket for the toilet paper, and the only thing they can do is use the bathroom until they get out. And then we'll have to go in and tear out the brand new floor tile and the floor and pull the toilet, which is brand new, by the way. And the toilet, the tub surround and the tub and the sink, will have to gut the whole bathroom. Thanks to Teresa Hale.
Okay. So.
Oh, and this is her mail that came after she left. She didn't leave a forwarding address. It's several unpaid bills.
Okay.
Teresa doesn't pay bills.
So what I have to determine here is what has been proven as damages. The court sees that there were unpaid utilities, the 30132 for the electric, and then 32418 for water, sewer, and trash. There's looks like $1,700 in back rent, $125 filing fee. Sounds undisputed. There was concrete in the pipe. However, there was a 2-week, 3-week gap between Ms. Hale moving out and new tenants, and there's no indication that came directly from her other than that was just discovered by the new tenant. So I can't hold her liable for that. So damages today are going to be the amount of $28.20.50. That includes the filing fees. And that can be paid through the clerk's office.
Yes, sir.
Okay, that's all for today.
Thank you, Your Honor.
Your Honor.
So she didn't get charged for the toilet.
No one was in that house for those 2 weeks prior.
Ma'am, we're done.
I'm just saying. She skated on that one.
Is there, let's see, Mr. Ron?
How much you want to bet she goes straight to the police station? She could file charges that way.
Collins here on Zoom. Sarah, Daniel Orango? Nope. 2512 EV 586.
I'm here for Syndicate Property Group for Daniel.
That makes sense. Yeah, we have your counsel's here on Zoom. Mr. Rollins, are you there?
Yes, Judge.
All right, if you can start your video. Call 2512 EV 586. All right, and we have, you can have a seat. Pick a side. plaintiff's here in person and by counsel, respondent fails to appear.
Don't pick that side. That side just lost. Go to the other table.
I see you've got some exhibits filed for a damages hearing. So is the request 312774?
And then plus the, it'll be $600 in attorney fees. Judge would prepare a final order to submit if you'd like.
Okay, yeah, I'll just find he has failed to appear. Looking at the claim.
So Judge, just to clarify, Judge, that amount included some costs. So the actual amount being sought is $2,809 and then plus 600 attorney fees.
2809 plus
Yes.
600 fees.
Yes.
All right, so looking at those, I'm going to take, show those admitted, those exhibits, and under default judgment, 2809, judgment plus $600 in attorney fees.
Okay, we will submit the order, Judge.
You're free to go.
Thank you.
Thank you.
Let's see. Your name's here in the blue.
Richard Howell.
What was the last name?
Howell, H-O-W-E-L-L.
All right, and Mr. Singh?
Yeah.
All right, you guys can come up to the table up here. Tables. So we're here for the receding supplemental. So Mr. Howell, the purpose of today's hearing is for Mr. Singh to figure out how this judgment's going to get collected. So I guess what is your plan to get that paid to Mr. Singh?
I came here today, Your Honor, honestly, just to ask for some mercy and leniency on that. I understand that he's probably seeking a wage garnishment, which is the most successful way for him to gain his payments. I just recently in November started paying child support and also got medical insurance. And my son is getting braces and his mother has asked me for $187 a month for 28 months.
Okay, so are you currently employed?
I am currently employed. I've held that job for several years. I am not opposed to a wage garnishment. I just am asking Harry, Pradeep Singh, and the courts to not make that a huge financial burden on me. Here in the next 3 weeks, I will be reduced to 30 hours a week at work at Wabash College because I work in the kitchen and we only do catering during the summer.
Okay, and just to cover this, where do you bank?
HHSB.
Who's your Heartland?
Yep.
I guess Mr. Singh, do you have any other questions for Mr. Howell? I don't need to turn this into a whole negotiation today. I'm just trying to find out what assets he has that you could then attempt to attach in the
I
future.
want to garnish any wages, but no any negotiation because yeah, it's already 3 years ago.
Okay. So what I'll do today is I'm going to make this eligible for garnishment. I'm not entering that garnishment order today. That's something you can request in the future, Mr. Singh. So Mr. Howell, continue. If you make some good faith efforts to pay this, that could go some way that can always be paid through the clerk's office. If you make those payments in the clerk's office, check gets sent to Mr. Singh. So that'll be all for today. So I'll make that eligible for garnishment. Doesn't mean one's going into place. You have to actually file something to request that. Okay. That's all for today. You're free to go.
Thank you.
No mercy is going to be shown, sir.
Let's see.
So,
Ready?
just for everybody who doesn't live in the United States, our blue cheese is probably way different than your blue cheese. Your blue cheese is actually real. Ours is not.
Portion coatings.
Right. Mr. Stoll here. All right. Coming up, but really we'll just call 2511 SC519. Let's see who's on the iPhone on Zoom.
Sarah Brock. I'm at work.
Not all right. No typing. So we will show the plaintiff has appeared for this proceeding supplemental, that the respondent has failed to appear.
I like blue cheese a lot.
So really at this point, just you can take whatever steps necessary. The purpose of proceeding supplemental is to see what they have to attach on that. If they fail to appear, you can look through. There's a small claims manual the clerk should be able to provide to you that shows the steps you're to take. I can't give you any legal advice on what you do next. Okay. So you can always talk to an attorney. or there should be a small claims manual to help you through that process. Okay. Okay. That's all for today. So, ma'am, your name?
Aerial students.
Let's see. Is there Mr. Crouch? It's 2601 EB27, Wyatt Crouch, beat Aaron Sudis. Both parties are here today in person
I like green apple Jolly Rancher shots. They're delicious.
for the issue of damages. Are the parties ready to go forward? Yep. All right. Looks like we were here back in March and Mr. Crouch, you'd requested $2,000, but needed some time to get documents together. Is the dollar amount still in dispute? Well, do the parties agree on a dollar amount or no? Okay. Well, then what I'll do is I'll place you both under oath, take some testimonies. Please both raise your right hand. You swear or affirm the testimony you give today is the truth, the whole truth, and nothing but the truth.
Yes.
So, Mr. Crouch, what do you want me to know today?
I have copies of the agreement we originally did back in February 1st. You said she was gonna buy all the material and everything to replace everything. And by the time she moved out, they'll do so. I got the quote right here. If you'd like to see it.
Okay. What's that?
It is $2,449. That's for the trim, repair, and paint, and wall repair and paint in the kitchen, and all the old materials.
Okay. So have you seen a copy of these, ma'am?
No.
All right. If you want to provide her with a copy of both the agreement you're talking about and that quote, and then you can bring a copy up to me.
Sure. Thank you.
What else do you want me to know, sir?
Want to come to agreement on this today and get it done and over with.
Ms. Sudis, do you have any questions
No.
for Mr. Crouch? Okay, what do you want me to know?
So, beginning our relationship, I'm just gonna kind of sum it up. I do have text message proof. We did go ahead because it says right here, because of the dog's damages, it was actually purchased for him. So within the time of those damages, that was his dog, of which had caused the damages. I do have video proof. I have text messages on when we were gonna go retrieve the dog. He said our dog. So I will come up with something to an agreement to where I can provide, because we did have something stated I would replace. Unfortunately, when I did move out, I did text you. I have a police report for stealing my mail. I have text messages. I have text messages asking you for my mail. That one day, the last day we were here for court, I did ask you if you had brought my mail like I had asked. Please bring it to court. That is a felony. And I do.
That is a felony. Wait, did you put ketchup on it? Because I'm starting to think that is a felony. Or tomato sauce. You call it tomato sauce. Did you put tomato sauce on it?
So the issue today is whether or not you owe some money based off an agreement for replacing some paint. So we're going to narrow it down to that.
I do have a video. I don't know if you want to hear it. Of I was asking him questions and I talked to him about the dog that caused the damages. I did ask him if it was his dog, but after.
Hold on, sir. She gets to testify.
I do have the video and it says within the time Lola was your dog. He said yes, but things changed. And I said, moving out due to not being able to provide for the dog, I'm going to take her. He said yes. I asked him if he agreed upon that. He said yes, he did. So within the time of the damages, it was our dog. I bought the dog for him. So this is what he's doing to replace his own house. Like I said, I can come up with something to help out with those because it was our dog, but I'm not gonna pay the $2,000 because I bought the dog for him. He didn't want the dog, he didn't ask for the dog. I do have registered as an emotional support animal, so she is now mine. Like I said, I got text messages proving that if we were picking up our dog, I have text messages showing dogs.
Okay, so, Ms. Hughes, is this your signature
Is it more like a spaghetti sauce or a ketchup? Or is it something sort of in the middle?
on this agreement?
Yes, it is.
Okay. So,
That was our original agreement on what I was going to replace moving out before anything was, oh, you owe me $2,000. So this was the original agreement to what I was going to come up with to replace, because I mean, everything that was done, I could even do it myself. So I had gotten quotes and I had told him about it and he said that was fine. And that's why we had signed and dated this. The $2,000 is an extreme. He did that too. He did the he got the quotes on his own. This was, again, our original agreement of what I was to replace moving out, and he was fine with.
okay. Any questions off that, Mr. Crouch? Okay, so I think a lot of moving parts. Sounds like there's a relationship that's soured. It's really just some money's owed somewhere for some damage to the house based on an agreement. It's a question of what, because all I have is a quote or not an extensive, overwhelming extensive amount of work.
Can I say something?
Go ahead, ma'am.
I will go ahead and go with the original agreement since this was stated and signed and dated before he decided to get quotes for the renovations. Anything that he had, if we come up with an agreement, we can work something out. I have never been against it. Moving out, I let you keep some of my stuff for your kids.
Saying back to the original agreement, I just have to decide a dollar amount today. What's your understanding of the original agreement of $1?
I'll split it in half. How about that?
Don't agree with that. Not in half. I will give him the $200 back for the dog and we can come up with quotes. Like I said,
You said you had the work quoted?
no, I didn't get anything quoted. I did write down prices on the stuff to replace what we had agreed upon.
So it's not like you agreed to.
We buy huge things of ranch and huge things of ketchup here because they're used often.
To replace paint.
No, Bobby.
Yes, so
Drywall patch, have that patched with plaster to fix the hole in the wall and replace blinds.
can I bring this to you? I did go ahead and get quotes on everything to have this ready. He said the cheapest was fine. We didn't have to go expensive. So we came up with prices as well, along with this agreement.
Okay. So see, there's basically just what is the baseline cost for everything without any effort of putting those things in. What I'm going to do today based off this agreement that's provided to the court and these ballpark numbers, I'm going to enter judgment. It's going to be $1,000. It's not quite half of what was asked for. I think the $250 hauling away materials in this smaller job. And some of the labor is outside of the norm for what is required here. However, the baseline materials, there's a lot of work that goes into replacing drywall, painting that, plastering. So that's going to be the judgment for today. And it's also you can pay that to the clerk's office, ma'am.
Can we have that paid through the courts?
Facts.
Yeah, that'll be paid. So the judgment will be entered and that can.
Mike goes spitting facts in chat, guys.
You pay through the clerk's
So-
office, so you pay that to the clerk.
And does that work?
Just clerk's office on the first floor. You can bring in. They won't take personal checks, but money order, credit card, payment online.
And when is the deadline for that?
I'm not setting a deadline. I'm just entering the judgment today.
Okay,
Okay.
Yeah.
That's all for today.
all right, wonderful.
And then she'll get back
I
together
do have a
with him.
question though.
Okay.
Within stolen mail, is that through small claims as well?
If you're alleging a criminal offense, that's goes to you contact police for
Never
that.
kept any of them, no mail whatsoever.
And then she'll get back with him and get the debt wiped away. And then leave. So when you say tomato sauce on the sausage sandwich from Bunnings, is that not ketchup either? That's it, like the different kind? I wonder if the tomato sauce you're talking about that's not ketchup but like ketchup, if it doesn't have as much sugar in it. Because ketchup has a lot of sugar in it. Alright, let's go here.
Next, I have a review hearing for plaintiffs Debbie and Terry Kari against Miranda Brown. This is 2310 SC 2027. I'll show Mr. and Mrs. Is it Kari? Kari. Ms. Kari appear in person, and Ms. Brown appears in person. Folks, this case was one where we had an agreed payment notification order for payment of, I believe it was $50 a week. And the defendant has made no payment since the time of the last order. And the last payment was made prior to our last hearing. So I'd like to start this hearing, Ms. Brown, by swearing you under oath. Please raise your right hand. Do you swear or affirm under pains and penalties for perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you may put your hand down. What is your full legal name?
Miranda Darylyn Brown.
And Ms. Brown, do you still reside at the 50660 Darlene Street, lot 132 address in Elkhart?
Correct.
And do you still work at Cheddar's Scratch Kitchen and Amazon?
I'm not at Amazon. I'm just going back into Cheddar's Scratch Kitchen.
Now you say you're going back into, so you're not back yet?
Yeah, I'm back. I got back on the schedule, but in November, my dad was diagnosed with stage 3 cancer. And we had to go right in and have brain surgery and stuff. All of December, we were at Memorial Hospital from January 12th to pretty much Monday. He's been on radiation and chemotherapy. I don't have any other siblings, so it was just me taking care of him. He doesn't reside in the States, so he had to come back to the States because he's lives in St. Thomas and the Virgin Islands. So as of Monday, he's to 1 chemotherapy week, and then he's off 3 weeks because we're progressing, like we're getting better. So he's better. Thank God for that. I have a letter from Memorial Hospital, stating that.
Okay. I'm going to ask my assistant Tina to come get that. And Tina, before you bring it to the bench, if you can show Mr. and Mrs. Kari, I appreciate it.
If I get some, Maiko, if I get some Australian tomato sauce, I will put it on a hot dog. Because I would rather try it on a hot dog than a meat pie. And Granny, their tomato sauce is different than our tomato sauce when they're talking about this stuff. So I don't know. It's closer to ketchup. What they put on top of their stuff, their Bunnings sausage snags or their meat pies. It's different, but we don't know how different it is. It's more like ketchup, but it's not ketchup.
Yep. All right. For the record, I'm looking at a letter with a letterhead of Memorial Regional Cancer Center, and it references that Bobby Darren Kelly is receiving daily treatments. has some dates. Basically January through, says March 5th. So a few questions, Ms. Brown. Is Bobby Darren Kelly your father?
Yes.
Okay, and I think a minute ago you mentioned that he was in treatments through Monday.
So when he stopped his treatments in March, they gave him like a 2-week, like where they wait to see if because it's a glioblastoma, it's something that doesn't ever go away. And they found on his liver, they had seen, it had like whitewashed when they put the iodine in for the MRI. So we had to go to Ann Arbor up there to where the university is for the liver. And we went there for that, but they said that they didn't see any cancer. So we've been through process with it. He's had to have 3 different images of MRIs and stuff with that, but we're good to go. He's gonna go back home.
Okay.
So
all right, well, first of all, I'm sorry that you're going through that. I will share, I lost my first wife to brain cancer, a glioblastoma, and then I lost my mom to brain cancer, glioblastoma. So I'm familiar with them. I know it's not fun, and I don't wish it on my worst enemy.
Yeah.
Now, that being said, while perhaps the plaintiffs have sympathy for your situation, I'm sure they'd also like to get paid.
Yes,
So
I agree.
I would like to see what we can do here to, I don't know if necessarily catch up, but sometimes what I suggest when somebody was previously ordered to pay $50 a week and, let's say, hold on, let me just do some quick math. 5 months later, 20 weeks, $1,000 should have been paid. I recognize that people who are out of work or had unique circumstances, they probably don't have $1,000 laying around, but I often suggest if they could maybe double up on their payments for a few weeks and then resort to the 50. I might suggest, let me ask some more questions about your work at Cheddar. Since you're no longer at Amazon, how many hours a week do you think you'll be working at Cheddar's?
I got, for next week, I got 35 hours and I picked up for this weekend, so.
And do you get paid by the hour or do you wait tables and get tips?
Right.
Wait, or both?
Correct. I wait tables and get tips. And then sometimes I work on the line, so sometimes I get paid by the hour. And that's, I think it's like $14 an hour.
Is the waitress hourly rate like $2 or $3?
$2.30.
$2.30. Okay. My daughter's a waitress, so
The
I
judge
do a
was
little
talking
bit of
about ketchup too.
okay. What do you anticipate being able to take home each week from Cheddar's?
Like $300, $400 a week.
Okay. So a quarter of 300 is 75. A quarter of 400 is 100. Do you think that you could do $100 a week for, let's say, the next 10 weeks and then resort to $50 a week?
Yeah, I can try, yes.
Is that acceptable to the plaintiffs?
No. We played this game when she accepted blame when the judgment came out. We have letter after letter, several with you, where she agrees to pay. She never pays. She never calls. She's got a million excuses. You told her last time you did not believe her. I don't believe her. It just goes on. And until you put something in concrete, she's not going to pay. We're going to be right back here again because she lies. You even told her that.
Would you prefer, instead of a payment notification order like last time where the burden is on her to come forth and make payment, that I instead issue a garnishment order so that
we've already done that.
We've done that too.
We've already done. What I'd like a body attachment put on her until she pays.
So I can't grant that request because she's here in court. She's explained the situation, so I'm not going to place her under arrest.
Okay.
I can either do the payment notification order that I outlined, or I can issue a garnishment order, and that is your call.
But you had her sign 2 different times. The first time was for $65 a week, and you granted her 3 months later to go down to $50 a week. She always has an excuse. We have lost families of our members of our family to cancer also, but what's right's right, and this has been going on for 5 years now.
Understood. I will share this with you. Some people are capable of planning, and when they have these major life things thrown at them, they're smart enough, they're wealthy enough, they have the right contacts, they can get through them. Some people don't have all that, so I have to consider that. You have a question, sir?
You said you can't put a body attachment on her. If she misses one payment, can you arrest her?
No, I can't arrest people for non-payment of debts. We don't have debtors' prisons in the US anymore. What I can do is arrest people if they disobey my orders to appear, for example.
Okay, she's disobeyed your order over and over again. There's two with you plus the original one.
But if there's disobedience of an order with justifiable circumstances, which I deem what I just heard to be justifiable, I can't issue that body sanction.
But if you go back to the prior two where she agreed to pay, she signed a document. That was before her song and dance story, which I still don't believe because she can make anything up, you know.
I understand your point.
Yeah.
I've already addressed, I'm not going to issue a body attachment. So we'll go back to the options: a payment notification order or a garnishment order.
The payment.
Okay. So then I'm going to put in place, Tina, a new payment notification order. Ms. Brown has confirmed she still lives at the same 50660 Darlene Street, address lot 132, Elkhart, Indiana 46514. She's still employed at Cheddar's Scratch Kitchen, no longer employed at Amazon. We're going to put in place, I'll give you, if you're just starting up this week, sometimes you get paid next week. So Friday, May 1st will be the first $100 payment due. And then it will be 10 consecutive payments of $100, starting with May 1st. And after those 10 payments of $100, it would go back down to $50 a week. And I'm going to set a follow-up review hearing while you're here, so there's no question about service and notice and what you need to do. I am going to order you to come back for a hearing after the 10-week period. Let me get myself to July. Let's do July 20th at 10 a.m. Since this is 10 a.m., I'll do 10 a.m. And then, Tina, I didn't mention this outside of court, but I would like to start when I have one of these hearings and I specifically order the defendant to be back. I would like you to write in, because it doesn't have it on the form, defendant is ordered to appear for the follow-up hearing of listing date and time. So again, July 20th at 10 a.m. Ma'am, I know you've made at least one payment in the past, so I think you know how to do that.
He did a garnishment before, Terry, and then she stopped working. So maybe that's why he didn't do it. I would have went garnishment too.
If you don't recall, you can take that white piece of paper at the corner. It tells you you can pay with cash in person. You can go online and use a credit card, although you'll incur a surcharge that way. Or you can mail a money order or cashier's check payable to the clerk with your cause number in the memo. Any questions about any of that?
No.
And then, Ms. Brown, you remain ordered to advise the court of any change of your address, of any change of employment, or of your receipt of any money greater than $300 through something other than employment, for example, a tax refund.
Okay.
Question?
What happened?
I have a question. Josh, did you have anything special to eat this week that maybe you made yourself?
Happens if there's no payments made and we come back again?
Okay.
What is going to be reprimanded?
Okay. I'm going to hope that she makes payment. And Ms. Brown, I want to look you in the eye and tell you, you got to do what I'm ordering you to do. I can't have an excuse every time we come back.
Yes.
However, I can't predict the future. And if there's some other life circumstance that happens and she explains it under oath, I may or may not sanction her. I might simply amend a payment plan. But we'll address it with all the facts in front of us when we come back in July.
She was supposed to provide her tax return payment today so you could review it.
Give me a moment to take a look at that order. Do you have tax information with you, Ms. Brown?
I don't have any tax information with me because we tried to like push it through and it kept ejecting it. So I ended up taking it to an accountant. So she's trying to like go through and figure out like what I owe. Because I'm
So you're filing it after the April 15th deadline?
So she was, it wasn't meant to be that way because we gave it to her on April 1st, but she said that it was rejected 3 times. So we had to like go to like H&R Block. So she's like going through the mess because it's and then plus she's dealing with my dad's. So we're just doing it that way. But in July, I can just bring it with me.
Okay, I'm gonna specifically order you to bring your tax return with you.
Yum. Coconut? Were they covered in coconut?
I don't want you to show up without it. I don't want you to tell me, oh, Judge, I forgot, or I didn't, or whatever. I want to see it.
Okay.
Okay? And Tina, let's also put on the payment notification order, defendant is ordered to bring her 2025 payable 26 tax return to court with her on July 20th at 10 a.m. All right, folks, if there's nothing else, I'm going to have Ms. Brown come up and sign this order, and then you're all free to go. Thank you.
Thank you.
All right, we are on the record in case 2406 CT 177. I'll show the plaintiff, Margaret Boyd, appears by its counsel, Ryan Milligan. I'll show that the defendant, Victor Manuel Millian Sodto, appears.
I agree, Crystal. I think tips are none of the government's business. They don't need to know about those tips. We still should get paid.
In person for himself. I want to start off by apologizing for the late start. I had a Kiwanis lunch meeting up in Elkhart. I'm still a member of that club, even though the courthouse is now in Goshen. And the way I went there was great, but the way I came back had 2 road closures. So anyway, here I am. Gentlemen, this hearing is a hearing that was set on plaintiff's motion for sanctions. I have reviewed the pleadings that were filed of record, and since it is the plaintiff's motion, plaintiff gets to speak first. What say you, Mr. Milligan?
Sure, thank you, Your Honor, and good afternoon. I'm prepared to talk. I'll just give you a brief overview of the timeline, but this case was filed in June of 2024. On January 31st, 2025, we issued discovery requests to Mr. Sodto, and we never got a response to those. On July 9th, 2025, the court entered an order compelling the responses by July 31st, 2025. We still don't have those. Fortunately, Mr. Sodto is here today, so what I'd like probably more than anything else just to be able to chat with him. We've been trying to determine since early on in this case, October of 2024, if he had insurance coverage on the property at the time, and also would just like to get answers to the discovery is really mostly what we want. And absent that, we have requested a default judgment as a sanction for the continued failure to respond to the discovery in light of the order compelling the responses on July 31st, 2025. But really, with Mr. Sodto being here, I'm happy to, if we can work something else out so we can just get the responses we want and some of the information we want. I'm fine with that outcome as well, Your Honor.
I appreciate the summary. And I think what might be the best thing for me to do is to place Mr. Would you prefer Mr. Sodto or Mr.
Milan? I'll go by Milan.
So Mr. Manuel Millian Sodto.
Yep.
Okay, Mr. Manuel Millian Sodto, please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
You may put your hand up. Sir, what is your full legal name?
It's Victor Manuel Milan Sodto.
And sir, what is your current address where you live?
It's 1311 Baker Avenue, Goshen, Indiana, 46526.
Okay. And what is your date of birth?
January 17, 1998.
Now, sir, did you receive the discovery questions that were sent by plaintiff's counsel about 1 year and 3 months ago in January of 25?
Yes.
Okay. Is there a reason why you did not respond to them within the 30 days that it states on the document it needs to be responded to?
Like I spoke to him a little bit outside. I had a lawyer and I thought he was taking care of everything. I had given him all the informations of insurance stuff, gave him everything he asked me for. Came to find out was when I was trying to get in contact, I thought he was handling it. After I got this paper, the notice of motion for sanctions, it got delivered to the 1311 Baker Avenue address. That's when I first saw it. So up to this point, I thought everything was getting taken care of on my end.
So let me back up a minute. So you said the first you knew of the fact that it wasn't, was that the July 9th?
Ever since this whole process has been going on, I thought he was sending me, we would have calls about what papers he received or what papers I received that I would give to him. And so I thought he was handling it on my end. So when he asked me for the insurance stuff, I gave it to him. When he asked me for the paper. I had a survey done on the property. He asked me for that. I gave it to him. I gave him everything he asked me for. I thought he was taken care of. So he told me that
was your attorney of record? Because I've been looking for a motion to withdraw.
I thought he was.
And he was not.
He was not. Like I've talked to him outside a little bit. I thought he was taking care of everything until I got this. I tried to reach him.
How much did you pay him?
Number's blocked. Don't know where he's at.
Okay, time out. Until I got this. What are you talking about?
The motion for sanctions when it was delivered to my 1311 Baker Avenue address. That's
on what date?
I can't recall because I had just gotten back from a trip, so I can't recall when I got it. But as soon as I got it, I called him right away. Well, first I texted him, and then no response. So I called him, and the number was like it was like I was blocked. So then I tried to go to this place where I met him, his office. It was locked. I left the paper, like I put it under the door, see if he could get back to me. Never heard back from him. So now I'm here.
Okay, what was the name of your lawyer?
It's on my phone. His name was Luke Cummins.
Okay, and then I still don't have the answer to my question.
Okay.
On that document you were just holding up, that you said I didn't know until I got this. You might not know the date that you got it. What's the file stamp date on it? Usually upper right-hand corner.
Can I interrupt briefly?
You may.
We have a proof of service. I don't know if it got filed before this hearing, but he was served by hand on March 15th with the motion and the notice of the hearing today.
My father received the paper because I
I'm
wasn't
gonna
in
make
town.
it too, Josh.
Okay,
I'm
and
gonna
was that
make one.
in March last month?
Yeah, it should be then. If he's saying that it's March 15th, it's probably around that time.
Okay, and I still want to know, actually, Ray, will you please get the document that the defendant's holding?
It says March 5th, 2026 on the very top corner.
Thank you.
Sorry, I didn't see it till now.
That's all right. I would like to set my eyes on it. Thank you. All right, so the document that the defendant was referencing is the notice of hearing on motion for sanctions, which has a March 5th, 2026 stamp on it, and it appears that it was signed on that same date. Attached to that was also the motion for sanctions that was filed on March 2nd. And Mr. Milligan, can you tell, since these are of record, I won't scan them in, you can give them back to defendant. You were telling me there was a date where there was service perhaps on defendant's dad. Did you know that date?
Yes, that date is March 15th, 2026. It was hand served by Ratty Investigative and Security.
I'm finding it hard to believe that his lawyer just up and left and blocked him. It just doesn't seem right. Unless he was disbarred, I don't know.
Agency at 3:30 in the afternoon.
And I want to go back before last month and talk about the July order. Give me a second to locate. I'm sorry, wrong spot. So this order of July 9th of 2025, which was about 9 months ago, that's the one that indicates, among other things, the court being duly advised now finds that Mr. Sodto's discovery responses are overdue and that the motion should be granted. And then Mr. Sodto's answers to interrogatories, etc., were to be completed and served by July 31st of 2025. Mr. Manuel Millian Sodto, did you receive that order sometime in the summer of 2025?
Yeah, I did.
And is it, am I understanding correctly that you thought that your attorney, who was not of record, but he had been speaking with you, you thought that he was going to be responding to information?
Correct. That's why, like I said, he was really asking me, like I said, because he asked me if I had a surveyor done on the property. I told him, yeah. He asked me for the paperwork, asked me for insurance stuff, gave him everything he asked me for. And at that point, my understanding, he told me that he was going to try to contact them to get an agreement or something. I thought it was fine. He's like, I'll reach out to you. Never did. Didn't hear from him until, like I said, until I got this paper, and I was trying to contact him, nothing. So that's why I thought I need to show up here. And I'm not trying to avoid anything, because I really don't. Like, I want to get this solved. I thought it was getting solved on my end. I guess not. But
did you retain copies of the things that you gave to
Yes,
your attorney?
you should tip.
I think I should. I should have it on my iCloud account.
Is there any reason why you did not, in anticipation of this hearing, print those things out and get them to plaintiff's counsel to say, hey, I didn't know about this till March 15th, but now that I know, I want to do everything possible to comply?
I didn't. No, I should have. Now that you're saying it, I should have. Yeah.
Mr. Milligan, do you have other questions that you'd like to ask of defendant?
So you mentioned that you had insurance on the property. Do you know who the carrier is?
It was through Progressive.
Through Progressive?
Yeah.
And that you had a policy through Progressive that was in effect on the date that this incident
It should have been, yeah. Because I have an auto policy. It's all combined in one. Auto, commercial, and then property.
Okay. And you understand, have you ever tendered this? Have you provided a copy of the complaint to Progressive and let them know that
should you tip the guy who comes out and makes a new key for your car when you lose yours?
This dispute's ongoing?
Well, he told me that he was going to take care of that and contact them on my behalf. That's why I didn't really, like I said, that's why I got somebody to do it for me. Because at the end of the day, I used to work transport. I was driving for a living. So I thought he was going to take care of that on my end. Come to find out, he didn't. But I should have all the copies, all statements I should have to Progressive.
Okay. Well, we can talk about this more afterwards, but if you tender the complaint to Progressive, most likely under your insurance policy, they'll provide a counsel for you.
See, I didn't know none of that. So.
Okay. Yeah, we can talk some more about that afterwards. I don't have anything further at this time, Your Honor.
Okay.
Fine.
So, Mr. Milligan.
Fine, V, then I'm not serving you one.
This hearing was set on your motion for sanctions. I'm happy to rule today. I'm also happy to take the matter under advisement to allow the defendant to make good faith efforts to provide the information that's needed with the extra incentive. If I don't do that, I might get hit with an attorney fee sanction. I'm not sure of the plaintiff's position on what the plaintiff's position is on that.
That sounds like a great approach, Your Honor. The second option, just to hold it open for now and see if we can work this out, and then we can follow up with the court as to whether we want to withdraw it or reset it.
Okay. And since usually the discovery, interrogatories, request for production of documents give a defendant 30 days, I would be inclined to give 30 days from today. So this is the first year knowing I'm without a lawyer. There are things I need to do. Yep. The court looked me in the eye and told me, contact Progressive, get with your insurance carrier, see if you have coverage, see if they'll appoint counsel, and answer plaintiff's question.
Yep.
And then I will take under advisement the motion for sanctions. If at the end of 30 days, the plaintiff has satisfactory documents and information, answers to interrogatories in their possession, the plaintiff might choose to file a motion to withdraw the motion for sanctions. Or they might choose to say, hey, we did take time to go to court and prepare this motion. We would have sought X amount, but we'll take less given the good faith effort, or something else. And by the same token, the defendant is welcome to file anything in response for the court to consider in the next 30 days, including even your discovery responses. If you want to show the court, hey court, this is what I did in response to our hearing from April 21st. Okay, so
sounds great.
In short, I'll take it under advisement, and I will, I'll note in my calendar May 21st, which I know is a Thursday, so that's a weekday. I'll be on the lookout for further filings or motions, and I will rule sometime after May 21st. Yeah, sometime after May 21st of this year. Any questions while we're all together? No. One other thing I might suggest, but I won't order, is, we had a little informal back and forth in court. If you both have 5 or 10 minutes, my guess is a private conversation for 10 minutes outside of court might be really fruitful in moving this litigation along. So I highly encourage that. And with that, I'll conclude the hearing.
Thank you, Your Honor.
Thank you, gentlemen. Have a good afternoon.
You too.
Thanks, you too.
All right. One more thing. One more clip. Oof. Small claim still. Landlord-tenant. Here we go.
Have a good day.
Hello. Hello.
No, they don't tip in Australia because they think that a server should be paid the same wage as any other hourly employee, and they should do their job with pride and happily and be a great server because that's what they're getting paid to do, which makes a lot of sense. Although I wouldn't like that.
Sorry, I only break up certain people's furniture, not everybody's.
No, I heard that. I just wanted to make sure you were okay. That was all.
I forgot we have to put stickers on stuff.
All right, so this is 25 EB 2446. This matter was heard on February 3rd. The defendants had failed to appear at that hearing date. We sent notice sent on February 5th, 2026 to the defendants at their last known address. That would have been mailed that day. The final order of possession was not effective until February 17th.
Michael, you're right. She was just trying to make everybody more cultured. That was so nice of her.
I don't have any information showing that those notices were returned as undeliverable. So we'll show the plaintiff failed or plaintiff appears. Defendants failed to appear. Now 10 after 11. Show the defendant's appearance is defaulted. Then would you please raise your right hand to be sworn in? Would you raise your right hand to be sworn in? Do you solemnly swear or affirm under penalties for perjury that any testimony you give will be the truth, the whole truth, and nothing but the truth? All right, thank you, ma'am. You put your hand down. So have you recovered possession of the property? Did you get the property back?
You know what? I didn't wear my hearing aids today and they're not very good anyway.
That's okay. Let me sit next to her. Sure.
Did I?
And you are, sir?
Yes, sure.
Her maintenance man.
Okay.
Did you get the rental property back?
Oh, yeah, we did.
And when was that?
Let me think. It was a month and a half ago.
The day of.
Yeah, I know.
So that February 17th?
Yes.
Yes.
Okay.
Yes, sir.
All right, are you ready to go forward on the issue of damages?
Yes.
All right, what would you like to tell me about what's going on?
Well, here's what I'm gonna do to speed everything up. I'm gonna just get through this thing straight. And I've got pictures for everything you want. I've got utility bills, so if you want me to put stickers on and give them to you, I can.
Jenny can do all of that. She's very good at that. So good at stickers, Jenny.
You don't want all of those stickers.
I'll take whatever you'd like to give.
Yeah, all to you.
All of them? These are.
I just found a job that I trained for my whole life, my entire life. So when I was younger, stickers were very popular with us, especially Lisa Frank stickers. So at recess, our playground was the parking lot. So it was like, cement. So we didn't like run around the lot in our little uniforms. We went to the corner with our little books of stickers and we traded stickers. It was just what we did, and we played Foursquare. This job right here, you get to spend the day putting stickers on all these papers. I need this job. I bet it also has health insurance. That's the job I want. Putting stickers on things all day. Now I do put stickers on things now grown up. They mostly say voice activated and they're almost always in a bathroom. But and other stickers I can't say right now because it's inappropriate. But I need her job.
Well, these people had.
So which one's before, which one's after?
6 dogs. Pardon?
Before and after.
Well, no, I don't have them separated that way. He did, and I went through them and I know.
Yeah. Okay. Just put them all into the bed or
This lady, as typical with people who want to ruin things, she and her husband had this story about the house they were in being sold. And they had to be at another house really fast. So, I've been interviewing on the telephone. I knew I didn't want them. But I was in the hospital with a stroke. And he's my go-to for everything. So he interviewed them and decided they were okay, because she is slick. So anyway, and he's okay. But the lease has no animals. She told me, she said, well, we have a dog and we have somebody's gonna take it. Well, it turned out they had 6 dogs. And they're pit bull style, which isn't small. And they kept them in the house. Because partly because the dog tried to bite a neighbor in front of the neighbor's home door. So they had 6 animals, 4 kids, and the house had just been renovated. Pretty much. So anyway, they broke off it was just, I want to just walk through the house. In the bathroom, they broke off the faucet, the hot water faucet. They chipped a brand new sink. Okay, or vanity, brand new. Nobody else had it. In the bed, okay, in the whole house, they asked Ryan never done anything like this before. So and some of those pictures are pee and you can't tell that. It's just hard for you to tell. So anyway, they asked for money to paint the house.
She keeps starting down one road and taking a left turn before she finishes her thought.
And he gave them a large container of paint. They went to the house and got paint on absolutely every floor in the house and rolled rollers across new cabinets. So he got that all, but we couldn't get the rest of the stuff off.
I have a reason you can go to a bank, friend, if you need one. I can give you 2 different reasons right now off the top of my head.
The bedrooms had paint on every floor and it was carpet, so it had to be replaced. The rest of the house had that new kind of flooring and a little bit of it would come up, some wouldn't, so we had to replace a lot of those floors. There were large holes. There were 3 large holes in the bedroom walls, large ones. 3 bedrooms, 3 big holes. So that had to be patched and painted. All the blinds in the bedrooms and the living room were all just ruined, messed up. Let's see here, the labor, I'm sorry.
The windows.
Yeah, I'll haven't got all that.
So.
Around that circle, the labor is in here, of course. The closet doors have paint on them, the kitchen, the laundry room cabinets, which are kitchen cabinets, which are new, had rolled paint on them. They messed up walls in the other rooms too, had marks on them from the kids, 4 kids running wild, and the animals. See, look at that one. They broke off the outside door to the garage, which locked. It had a combination and a regular lock. They broke that off. They had 3 windows broken, large breaks, and her husband said she did it. They were just like the ones in the bedroom, great big large breaks
Did I?
in the all the living room windows. They let's see here, the floors in many rooms had large pea stains all over, and it made the flooring curl. If it wasn't carpet, it curled. If it was carpeted stuff, so it couldn't be clean. Let's see here, the entry door, of course, had a broken door and a window in it. The front yard, believe this or not, they did wheelies in the front yard.
Burnouts,
Be it burnouts or whatever they are, they did in the front yard. And let me think here. There were supplies, of course, we had to replace things. And Ryan said there was about 100 bags of dog poop in the house and out of the house. So I forget.
backyard.
Yeah, well, trash bags and a busted up. You're good at breaking things. There was a busted up table and chairs in the backyard, not fixable, and bags of trash in the backyard. They owed $572.54 in combined utilities. I have the bills here if you want them. And they paid in rent $44.75, and they should have paid $94.75. I put the deposit towards rent.
How much was the deposit?
The deposit was $1,500 and the rent was $1,500.
So the deposit, the rent that you're saying, you said that they basically owed you $5,000 in rent.
No, they put $3,000 down. $1,500.
No, do they owe you $5,000?
Oh, well, yeah, they owe.
You said they paid 44 and owed 94.
Yeah.
So is that with or without the deposit already subtracted?
That's without deposit subtracted.
So the deposit would be another $1,500.
Well, no, I put it as rent. I added.
She added it to.
Oh, okay. So the deposit was added to
I
the
just
40.
took all the money I got against the money I.
Okay. So when you say they paid 4,400, that's including the deposit?
Yes.
Okay, that's what I wanted to make sure.
Yes.
Okay. So you said they owed you $572 in utilities.
Yes.
And a total of $5,000 in rent. What other damages? So you're saying there were damages to the house?
All the new floors and labor and.
And how much was that?
It was well over $6,000. I took out a $6,000 loan.
Okay.
And a sheet for him. We'll give it for him. You know what? I had a sheet for you.
Okay. We can take that as exhibit 3.
Okay. Yeah,
More
that one.
stickers.
Good as the other.
I think she's suing for $9,999.
Now,
Even though
all the
it was more.
utilities, fortunately, there's one page that has the total on each. So if you want that, I've got that for you.
Sure, I'll take that as well.
Okay. Here's the. I just didn't know how much junk you want up there. It's just.
It could have been the other lady, Kelly. You're right. They all sort of swirl together in my head.
Okay. Ma'am, is there anything else you'd like me to know?
No, other than she's very charming and says I'll pay the rent on time and pay the 5-6 days later. If at all. Yeah, at all.
All right, I will show that the plaintiff appeared in person, the defendants failed to appear, their appearance is defaulted based on the evidence and testimony presented, judgment entered in favor of the plaintiff on the plaintiff's complaint. That is joint and several as to both defendants. What that means is that the judgment is kind of a lump sum against both of them. So if they both pay $5,000, okay. If one of them pays $10,000, okay, they don't both have to pay. But I am finding, I'm capped. The most that I can award is $10,000 in damages. And inclusive of rent, utilities, the damage to the property, the rent and the damage to the property alone, based on your testimony, is over the.
You're right, Maiko. You're right, Josh. The maintenance guy is happy and he's cheering over there. She's never getting that money. Never, never, never.
$10,000. So I'm limited in how much I can award, but I am going to award judgment in favor of the plaintiff in the amount of $10,000 plus court costs and sheriff's fee, judgment to bear interest at the rate of 8% per year according to statute.
And we did try to keep costs down. We didn't go out and buy something. I mean, we got things on sale and.
Oh, I understand.
Just the best we could do.
Okay.
That family is a moving destruction department.
All right, Ms. Sergeant, I wish you the best of luck.
Thank you.
Thank you, ma'am.
Will the courts contact her with how to receive her money once they start garnishing his?
Well, so garnishments don't happen automatic. So what I would direct you to, Ms. Sergeant, is I would tell you that it's a good idea to look at what we call the Indiana Small Claims Manual. That's a manual that we have online available to all parties. It'll help give you guidance on what can happen now that there's been a judgment entered.
All right.
Because garnishments don't happen automatically, you have to file for them. But you have to wait a certain amount of time.
Thank you.
I know how to file. Thank you, sir.
Thank you. Good luck.
You too.
All right, guys. Thanks for coming out. I appreciate it. I hope that you guys have a great, great Thursday. And I'll see you Friday morning. Bye, guys. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain. 'Cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. see for yourself.